And greetings and welcome to part 3 of Fraudulent Conveyances and Transfers, Diminution of Debtor to the Detriment of Creditor from American Jurisprudence. Tonight we're going to be going over part 3 of this particular volume. This comes from, let's get to we also have Black's Law Dictionary, 9th edition, to make sure we leave no word behind. And we're going to be using 2nd edition of American Jurisprudence, and this is from the November 2022 update. We're going to be starting here on section 166. We left off last time going over pretty much the issues that might come up during fraudulent conveyances. On the first section, part 1, we dealt with essentially what they are and why they should matter. And the section 2, we saw pretty much some of the situations that you would find fraudulent conveyances causing legal issues in. And here in part 3, we're going to see exactly how these issues come to be litigated in court. So with that being said, if everyone is here and is hearing me loud and clear, please let me know in the chat. And of course, hit the like. And we're going to get started right away on this. Okay, so section 166, trustees and beneficiaries. A trustee holding legal title to property for the use of others is usually considered a necessary party in a suit attacking a fraudulent conveyance, on the ground that the court can do no more than act on the legal title of the parties before it. However, it has also been found that a court of equity may proceed against the parties before it in the absence of another party holding a mere legal title to the property in dispute in trust for the benefit of the parties before the court. The question has also risen as to the necessity of making the beneficiary of a conveyance in a trust a party defendant in an action to set aside as the fraudulent conveyance creating the trust. Generally, if the trustee is not a party to the action, the beneficiaries named in the conveyances must be regarded as necessary parties. But where the trustee is a party defendant, he or she may be regarded as representing the beneficiaries, so that the suit may be maintained against the trustee alone, without making the beneficiaries party defendants. So here's where we're finding out where you're going to have standing and against whom with the jurisdiction too, for the personal jurisdiction that you're going to bring for this action for a fraudulent conveyance. But before I say anything further, I just want to remind everyone that this is strictly for entertainment educational purposes and not to be construed, used, or utilized for any of your legal, lawful, financial, or personal use. Don't do this at home. All right, let's continue. So the footnotes here, we have pretty old case holdings here. 1926, 1879, and 1951, 1930. And let's see here, 1941 also. Let's continue. Section 167, lien holders and assignees. A plaintiff bringing an action to set aside a conveyance of real property as fraudulent and to declare the subject deed null and void. It is generally required to join the mortgagee of the subject premises as a necessary party. While a mortgagee or other lien holder has been found to be a necessary party defendant in a suit to set aside a fraudulent conveyance, it has also been considered that a bona fide lien holder is not a necessary party defendant. an assignee in bankruptcy and an assignee for the benefit of creditors have been considered necessary parties. Interesting. So an assignee in bankruptcy could be considered a necessary party and an assignee for the benefit of creditors. So where we get to the assignees, this is another issue here where you need to bring up issues here for standing. All right, let's see here. Section 168, corporations and stockholders, insurance matters. Oh boy. Where a debtor fraudulently conveys his or her property to a corporation formed and controlled by him or her for the purpose of hindering or delaying his or her creditors, the stockholders of such corporation are not necessary parties to a suit by creditors to such real property. Okay, so seems like the stockholders aren't going to be held liable for this fraudulent conveyance, nor is a corporation whose stock has been fraudulently conveyed a necessary party to a suit to set aside the conveyance. Well, that convenience. Where the fraudulent conveyance or preference relates to the proceeds of an insurance policy or funds spent in paying premiums on such a policy, the question whether the insurance company or the beneficiaries named in the policy are necessary parties depends upon the particular circumstances in each case. So the particular circumstances is going to determine whether you're going to be naming, let's see here, the beneficiaries as necessary policy or necessary parties. All right, let's see who else they're going to name here. All right, we're just talking about the beneficiaries right at this point here. Thus, for instance, in an action brought by creditors of the descendant against his sister to set aside an assignment of insurance policies to her, the contention that the insurance company should be a party defendant has been rejected on the ground that since it has already paid over the money secured by the policies, its presence was not necessary to a settlement of the controversy. All right, a little complicated there. Of course, that's the corporate insurance side of it. Hopefully, that's not applying to anyone listening here. Let's see, we have research references. All right, now we're on to the good stuff here. This is where the rubber meets the road. I hope everyone's here. Seems like we don't have a lot of people here right now. I'm kind of wondering if this notification even went out. What it seems like we should do here at this point is, this is where I wanted to start anyways. So I'm going to restart the stream and do this continuation. And we're going to start here on making the complaint or petition generally. And as I said, this is where the rubber meets the road. It's important stuff. I want to make sure we have a good audience here. So on that note, I'm going to sign off from here. And we'll continue next time with part 4 of fraudulent conveyances and transfers, diminution of debtor to the detriment of creditor. And we're going to start with the complaints or petitions. See you then. Peace out.